particular slides, I do have notes and PowerPoints that you can already read, but this is just a way for you to hear some of my additional comments. But again, if you want to just focus on the PowerPoints and the notes, then you're going to be in good shape. That'll be fine. As always, if you've been looking over this text, you can see at the very beginning they have a really nice section on introducing the topic to you. So here you can see some ideas there. You can get a good sense of what civil liberties mean. And so focus on that, page 114 there in your text. So you get that idea that it's a protection from the government. And this is a very interesting movie that shows that need for knowledge about how an individual can protect himself or herself from the government. This is a very controversial movie. Some of you, if you'd watch this, you may be quite offended. And it was highly rated, but yes, I'll give you fair warning. There will be things in this movie that many of us would find this offensive. But I believe when you watch it, you do get this idea of the need to know your basic rights when you may be in a situation where you feel quite compelled to do things that you don't want to do, that you feel like you're being forced to by the state, by the government. How do you counteract that? And civil liberties gives us an idea of how to do that. The movie Compliance was based on a real event involving a real person. So you might want to Google Louise Ogburn and you'll get a sense then about what ordeal she went through. And again, reading through this chapter, you can get an idea of how to prevent that from an individual perspective. So early on in the text, you see mention here about this particular court case. And it's interesting to think about this. It's occurred in World War I. And look there at that question, is there a difference between peacetime and wartime speech? Should there be? There was an outcome of this case to conclude that there would be. Should there be a difference though, right? Because might there be a motivation among the government to always be at war if they can crack down on speech more during those situations? If there's a threat to people, then we perhaps can understand why the government may need to limit someone's speech. But if you're going to just protest a war, is that a threat? So there's a lot of questions and complications here about this case. You can read about in the text. May also want to Google and just get some your own for your own enlightenment, some information about this case. This is where we did get this famous phrase. Some of us perhaps have heard this before: clear and present danger. And so if speech activities present a clear and present danger, perhaps they should be reduced. But who's interpreting that clear and present danger, right? That's always a major challenge. And so we see those issues still brought out today. This was a case involving Bradley Manning. Bradley has gone through a transition sexually, and so no longer known as Bradley Manning. But when he did commit these crimes, he was Bradley Manning. He was convicted of these crimes, but not everyone views them to be crimes, right? You can see here from this PowerPoint slide, exposing war crimes is not a crime, is it? He was tried and convicted of it, but what exactly constitutes a crime? Perhaps not everyone feels that way, but it was a jury that made that conclusion. So when can speech be limited? And perhaps also because of the nature of one's job, speech might be limited. So do we make a distinction between verbal speech and nonverbal speech or symbolic speech? So you can read about this starting on page 127. One of the more infamous situations, of course, that many of us are aware of involves the Westboro Baptist Church. That's mentioned here in your text. So speech that might be quite offensive might still be allowed, such as flag burning. Then we look at speech in another context, and this is looking at what might be obscenity. It comes from the case that the test that's used to determine obscenity is called the Miller test. It's based here on this court case, Miller v. California, 1973. On page 130, you'll see these standards for the Miller test. So notice then that if a work failed one of these standards, then a jury could find the work to be obscene. So for all this, when we look at the issues of speech, we come back to this question of balance. And that's, I think, a very important approach that you should have when you look at these issues. Do you balance out the rights of the individual versus the need to protect society? Should one part of the scale tip more than the other, or can you balance them out? And maybe it's different from one situation to the next, but there you can see this ongoing quest to find a balance between the individual and society. We also have the issue of religion, very important, of course, and it was actually the first of the rights or freedoms that are brought out in the First Amendment. And if you look over these pages here, you'll see these two important clauses in the freedom of religion section of the First Amendment. The freedom to avoid a state religion establishment clause, and the freedom to exercise one's religious beliefs as one sees fit, the free exercise clause. So focus on those. Here we can see the basic rights that are for those of the criminally accused. Doesn't necessarily mean someone who's committed a crime. Could be anyone, as your text points out, that just finds themselves in a really bad situation and doesn't know how to effectively respond to it. And that's, again, what those rights are for. And that was that situation that I mentioned in the movie Compliance, the inability of a young woman working in a restaurant to be able to conjure up right at that point her basic rights and be able to use them effectively. And so if we had that knowledge, perhaps we would be able to avoid some very difficult situations. But these are then rights for people who are guilty, but those who are not as well, and need to find a way to be able to represent themselves. So read through on pages 133 to 140, the rights of the criminally accused. So we know about the search and seizure. I think any of us who watch any kind of police shows on television, Law and Order, we know about search and seizure. And it does raise some very important questions. What is the most effective way to ensure that law enforcement, the criminal justice system, obeys the Fourth Amendment? And we can see some fuzzy words in the Constitution. Once again, unreasonable. What exactly is that, right? So there you have this case-by-case basis of trying to determine what is unreasonable. The rights within the Fifth Amendment, the grand jury, a large jury that determines whether there's evidence to bring a case to trial. So a person is not guilty from the grand jury, but they are indicted where they would have to go on to another case. Double jeopardy, no retrial for the same offense. Discrimination, cannot be compelled to be a witness against yourself. And it's an interesting one here, eminent domain, that you have value for private property that is going to be taken for public use. You still will be paid for it, but it will be paid based on the market value for that property. You have the right to an attorney, and this brings up an additional case. Originally, the Sixth Amendment, well, what the Sixth Amendment says is you have a right to an attorney. It says nothing about do you have a right to an attorney if you can't afford one. And that was brought out in the case here involving Clarence Gideon. He was able to successfully appeal to the Supreme Court that for him to have a fair trial, he needed to have an attorney. And he wrote out his own appeal, that's referred to as a writ of pauperis, and the courts agreed, and he was retried and found not guilty. So there are court cases that create new interpretations of these amendments, such as the Miranda rights that are involving the Fifth and Sixth Amendments. And this involved Ernesto Miranda, by all accounts, not a good person, and he had done a lot of vicious things. However, does he not also have the right to know about his basic rights? And that was the conclusion from Miranda v. Arizona. He had a right to know about those. And there continues to be interpretations of the Miranda rights. So here we have this issue of you have a right to have some break between the times the police are asking a person questions who's a suspect. So as we can see here, it seems to be rather kind of a random number, right? Every 2 weeks, there can be, once again, a time of asking a suspect. But it can't be every day that you just haul the suspect down to the police station and start asking them questions. The exclusionary rule from the Fourth Amendment, and what happens then if the evidence is gathered in an unreasonable search. And that involved this defendant, Dahl Ray Mapp. So the exclusionary rule, as you can read about in your text, the evidence is not admitted into court. This may very well mean that a person who is guilty goes free. And this is the dialogue between two justices who were talking about the outcome of this case, Mapp v. Ohio, that created the exclusionary rule. So as you can see here, these two justices had some real problems about letting a guilty person go free. I mean, we don't want innocent people in prison, but I think we would also want guilty people not free. So how do we ensure that that happens? But is there something even more important than innocence or guilt in one particular case, and the justices are focusing on what is the correct interpretation and the correct protection of the Constitution? Then you have the Eighth Amendment, protection from cruel and unusual punishment. And this is, of course, primarily focused on the death penalty. The death penalty, every time there's a change in the death penalty, it's supposed to be more humane. And it's a very fair question, right, to say how do we really know that it's humane, right? I'm not sure if we can ever make that conclusion. It does mean that there are people who have been convicted and later on were found not guilty. This is something you might want to check. Again, free to utilize the web, and you might want to Google Innocence Project and look at the number of people who have been found not guilty who were in prison, some on death row. So Greg Wilhoit from Oklahoma was guilty. He was on death row. He was days away from being executed and was eventually exonerated. So if we've been days away from executing someone, I think it's fairly safe to say that somewhere along the line, our criminal justice system has executed people who were, in fact, not guilty. So this leads us to this question from Dr. Franklin, again, in a way looking at balance, right? Here you see this quote from Franklin: "Those who sacrifice liberty for security deserve neither." So should we focus on liberty the most? And when we start to take that away from people, how are we ultimately secure, right? That can be some of the questions that, a major question for us to consider. And then we have the right to privacy, and it can be interpreted from several amendments. Some of these we've covered here, the Fourth and Fifth Amendments. The Third Amendment protection from housing soldiers on your property during peacetime, suggests a zone of privacy. The Ninth Amendment, rights that are not specifically written down are not to mean that they don't exist. And so is one of those rights the right to privacy. We know of other unwritten rights that are covered by the Ninth Amendment. That's happened in particular court cases. You can teach a child a foreign language. You can send children to private schools. Nothing of this in the Constitution, but does it need to be that specific in the Constitution? Right to procreate. This has been somewhat controversial, depending on people's IQ levels and their right to be able to reproduce. But the courts have ruled the Constitution gives them that right. It's an unwritten right. The right to travel abroad. You have a right to go to Mongolia. And does there have to be an amendment to the Constitution that says you have the right to go to Mongolia? There you can see perhaps the need not to be that specific in the Constitution. Let's look at this issue of privacy. Where are the limits? And we can see in our society some issues that are controversial to many people. The right to end a pregnancy, and the right of same-sex couples to marry, to live together. And so that is currently how the Ninth Amendment and the Fourth Amendment, the right to privacy, is interpreted, how they are interpreted. So focus here on nationalization of the Bill of Rights. This has been the process here of making sure that the Bill of Rights applies the same in all the states. And that is very important for us to ensure that the rights that a person enjoys in Vermont will be the same rights, the interpretation of those rights that someone would enjoy in Oregon. So that's a very important part of this text in Chapter 4 to read, pages 116 to 120. We'll stop there, and we'll be focusing on the fifth chapter that focuses on civil rights, the rights of groups, protections of groups.